Good morning. The hearing board is in session.
It's the ghost.
Is someone's phone
On?
Is dialed into the webcast?
No?
So the sound's loud. Tablet, perhaps?
Testing. Good morning, everyone.
It's a Halloween treat.
We're trying to find the echo. Okay. Good morning. The hearing board is in session. Today is Thursday, October 27, 2016. We're meeting in the hearing room at SCAQMD headquarters in Diamond Bar. The time is 9:03 a.m. And the matter we're hearing today is a continued matter, petition for an order for abatement, SCAQMD versus Sunshine Canyon Landfill, case 3448-14. Who's representing the executive officer this morning?
Good morning, Nicholas Sanchez on behalf of the Executive Officer.
Thank you. And representing respondent Sunshine Canyon?
Good morning, Mr. Chairman. Tom Bruin for respondent.
Good morning, Mr. Chairman. Bill Beck and Bob Rooney for respondent also.
Thank you. Those who will be testifying today, please rise to be sworn in. Raise your right hand. Do you promise to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Thank you. At the end of the day yesterday, Mr. Wade Hunter of the North Valley Coalition of Concerned Citizens kindly agreed to postpone his planned testimony until this morning so that we could have the opportunity to complete the testimony of Mr. Larry Israel and finish that intact. And we appreciate that very much. Before I go to Mr. Hunter for his testimony, Mr. Sanchez, any preliminary matters?
I don't believe so, Mr. Chairman.
Mr. Bruin or Mr. Beck?
No, sir.
Okay. Mr. Hunter? Good morning.
Morning, is this on? Yeah, I couldn't tell if you could hear me or not. My name is Wade Hunter, W-A-Y-D-E-H-U-N-T-E-R. I am the president of North Valley Coalition Concerned Citizens, Inc., and I have been sworn. Yesterday, I did give you a copy of what I plan to speak on, so you should have that before you. Unfortunately, my first title was Incorrect Description of SQMD NOV Procedures in Legal Filings, and if you have a look up, I believe you're looking at a date of November 26th. That should be changed to October. I was not planning to put this particular material in until a later date, so I obviously missed that. Anyway, to start off, BFIC / Republic in BFIC versus SQMD in Superior Court case number BS 163753, memorandum of point authorities, ISO motion for issuance of writ of mandate under item C lines 11 through 19, page 4, erroneously describes the procedure for NOV citations, claiming that after the inspector smells odors at 6 complainants, he issues an NOV. This is incorrect. The inspector must trace the odors back to the source, verify that indeed it's coming from the landfill, then he must go back to the complainants. and obtain at least 6 signed complaints before an NOV can be issued. Also, multiple reports of odors on the same day from the same address are only recorded as 1 call. Additionally, in their legal filings to Superior Court, declaration of Thomas M. Bruin in support of petitioner's motion for issuance of writ of mandate ordering compliance with the California Public Records Act under item 6, lines 3 through 11. Again, the SQMD NOV procedure is misstated by not including the fact that 6 complaints must be signed before an NOV can be issued. In effect, this procedure gives the landfill the benefit of the doubt, and not the other way around as claimed by them. There's also a failure to address individuals' sensitivity to odors. BFI/Republic fails to address or recognize the well-documented differences in individual sensitivity to odors in their overarching legal argument on the repeat number of persons or homes reporting odors, and in their summary dismissal of all those calls, either attributing them to being motivated by greed in the form of a lawsuit or by persons dedicated to closing the landfill. BFIC/Republic also describes the odors as faint and fleeting. We have included in that particular handout an excerpt from the first 3 pages of a 27-page report from an earlier version of the SQMD report, which was provided to the public for the month of October 2015, and that was recording 370 reported calls. And if you look at that time, as I said, it's behind this speech I'm making. At that time, it included descriptions of odors as reported to them, so whatever they were taking over the hotline. As you can see from the first 3 pages, they're anything but faint and fleeting. So if you look over there, you will see just people's descriptions as they were calling in. As I said, it's 27 pages long. I gave you the first 3. However, I do have the report here if you'd like to see the entire report. Even if they had been faint and fleeting, which BFIC and their attorney like to impute, and which we know that they mostly are not, they are odors as such. Republic has no right to pollute the air of our community and threaten our health, safety, and welfare. If odors are generated on their property and stay on their property, that is their business. But once it leaves their property, it is trespass, and it is our business. And Mr. Rob Sherman, the Sunshine Canyon Landfill's manager, is fond of recounting how he checked at the Van Gogh Elementary School for 18 months after he arrived and didn't smell anything. And I don't say he didn't smell any. I believe he said, if I did smell anything, it was faint and fleeting. Now, I'll correct that statement. It is a given fact that he was working at the landfill and would have suffered olfactory fatigue. And I have an asterisk in here, which I define on the next page, what olfactory fatigue is. And let me just turn over to that. And basically, going from Wikipedia, the Free Encyclopedia says, olfactory fatigue, also known as odor fatigue or olfactory adaptation, is the temporary normal inability to distinguish. Do I have 5 minutes? Oh, I'm sorry. To distinguish a particular odor after a prolonged exposure to that airborne compound. For example, when entering a restaurant. So basically it's saying you get exposed to an odor, you're going to be desensitized. So it is a given fact that he was working at the landfill and would have suffered olfactory fatigue and would be desensitized from the very first day working at the landfill until he could no longer smell the trash. I understand that was a recent study produced that indicated that daily exposure to trash odors would result in a loss of olfactory senses within 8 months of working at a landfill. Now, I've been searching for the report. It was told to me. I haven't found it yet. I will. But I just want you to know that you work at the landfill, you can't. And we had an example today. Yesterday, if you remember, where the SCAQMD inspector came together with the person from the LEA, and they met the guy off of the landfill, and they got out of a car, smelled the odors, but here comes the guy, he's having a problem, that worked at the landfill, which I think really makes our case. So If I still have some more time, there was a couple of things that came up yesterday during Mr. Thompson's testimony. I think it was Mr. Lerner was asking about how much leachate could be generated. And while this is not exactly the answer to what you want to look at, if you remember those charts that I provided to you, it talks about the leachate being generated. And if you look, for instance, in 2009, there's about 207 million gallons. Okay, if you look in 2015, we're now up to 5 million gallons. So basically a 100% increase. Well, what happened? Since that time, we put in about another 14, 15 million tons of trash, and that's gradually decomposing and working its way through the system. So while that's not exactly the answer to your thing, you get some idea of the potential based on the millions of tons of trash they're adding at 2.3 every year. Million tons of trash, how it will increase the amount of leachate being generated. The other thing was, when he was asked about who would be responsible for the holdup in ice, or at least a problem, he said planning. I would say to you it was County Public Works and the task force that had a problem with what was going on, and that was because the conditional use permit. And also the other thing, there was off-site spacing, because they were talking about detecting migration of gas off-site. And I think there was a question about the probes, and I think mine is either 500 or 1,000 feet apart. So anyway, and also, if you just a point of reference with that particular report, with the 370, if you look to those charts that I provided, 12AB or exhibits 12A, B, or C, you will see on that particular time period that the 370 are plotted there. So, which is, again, October 2015. So you can see it appearing on the charts that were provided by the Public Works to me. Thank you very much. Appreciate the opportunity to speak.
Okay, the document that you submitted titled the SCAQMD Hearing Board Sunshine Canyon Landfill Odor Abatement Hearing, date November 26, which you corrected to October 26.
Yes, sir.
We'll mark that as Public Exhibit 14. And I think the timer might have
Explain.
jumped ahead. Anyway, I allowed you a little extra time.
I appreciate that.
Thank you very much.
Thank you.
Any questions, Mr. Sanchez?
Thank you. Mr. Hunter, are you still the president of the Sunshine Canyon Landfill Community Advisory Committee?
It's not the president, I'm the chairperson.
Has the committee been provided the proposal for the intermediate cover project to be applied at Sunshine Canyon Landfill?
At this point, yes, there is information. I sent out what I received to the board, asking them for comments. I also, a subsequent meeting where Mr. Sherman was presenting, there was some information that we did not have. Mr. Sherman provided that, and I resent it to the board, asking them to complete and get back to me with comments.
So the board or the committee hasn't taken an official position on the cover yet?
I haven't seen their comments back. He was at, and I stated, when I sent out to the board, I believe in June of 2016, that he was at or July, there was a meeting that he came to. We talked about ice. At that time, he was talking about Pawsey Shell, which I indicated that I knew all about, felt there was a lot of potential in it, and at that point, nobody in the board expressed opposition to that program.
Are you personally in support of that intermediate cover project?
I believe it's worthy of trying, yes.
Thank you. No further questions.
Mr. Beck?
Mr. Hunter, I just want to clear up,
Sorry.
did you say you're president of the CAC, not just the North
No,
Valley
no,
Coalition?
I'm the chair of the SCL CAC.
You're the chair, okay,
I
thank
am
you.
the chair.
And again, just to get the record so that it can be correctly indexed, you testified in late August at the public hearing. You
Yes, sir.
testified this past Tuesday, October 25th. You're testifying again today, October 27th, and I expect you'll be with us for the duration.
Yes, and I expect to testify the afternoon during public comment also, and every other subsequent hearing that we're going to have.
But I'm testifying as the president of the North Valley Coalition of Concerned Citizens, Inc. I do not introduce anything from the SCLCSC, although documents may come from them, which we normally distribute to the community.
Okay, thank you.
Thank you.
That's it. I'm good.
Okay, any other
Sorry.
yeah, board members? Nope. Thank you very much.
Thank you.
Okay, if there's nothing else, Mr. Sanchez, we'll go to your next witness.
Yes, thank you. The district would like to call Mr. Christopher Ravenstein.
Just a second.
We had Mr. Israel here yesterday, and he finished his testimony, but nobody had a chance to ask him any questions.
We will.
Yes, we're going out of order, Senator. Just sometimes what happens in these long-term hearings, we try to, for efficiency, we try to call people to make sure they're available at certain times. Mr. Ravenstein has some other projects that are going on, and for his convenience, which I asked from respondents, if we could have him briefly this morning, and then we can resume with Mr. Israel right after.
And Mr. Sanchez did advise us of that, I think it was late yesterday.
Thank you. Mr. Ravenstein, can you please state and spell your name for the record?
My name is Christopher August Ravenstein, last name Ravenstein.
And did you take the oath?
I did.
Who is your current employer?
The South Coast Air Quality Management District.
And can you summarize your employment history with the district?
I was hired at the district in 2006 as an inspector. I inspected industrial toxics facilities, including lead facilities, asbestos abatement projects, hexavalent chrome platers, and landfills. I was promoted to staff specialist in December of 2015.
And are you familiar with District Rule 1150.1?
I am.
And what is your understanding of that rule?
My understanding is that owners or operators of active or inactive landfills are required to comply with the rule by controlling both methane and non-methane emissions.
And how do they measure those emissions?
They use different pieces of equipment to measure hotspots and integrated averages over grids at the landfill and also perimeter probes.
And do they report their observations to the district as part of, as required under that rule?
They do.
And what is that process?
Different landfills have different reporting requirements. Sunshine Canyon Landfill reports quarterly.
Okay. And what are the different timeframes or allowed timeframes for reporting of that data to the district?
Inactive landfills that have no history of gas production are allowed to report annually, all the way through active landfills that have demonstrated gas production are required to report quarterly.
And is Sunshine Canyon Landfill in compliance with its reporting frequency to the district?
They are.
And so what is it that actually comes to the district to report those emissions?
The landfill produces a report, either paper or electronic. The reports that I reviewed were electronic copies. They report the instantaneous, the lab analysis results of the samples collected, integrated samples that they've analyzed, and probe results.
There's been testimony throughout this hearing in regard to instantaneous and what's the other word that I'm thinking of?
Integrated?
Integrated readings at a landfill. Can you explain to us what's the difference and how those are reported in the report?
Instantaneous measurements are for things that could be a leak, whether in a collection system or at a wellhead or at an accumulation point that is not over the entire surface of the landfill. Integrated reporting is the average measurement over a 50,000 square foot grid measured over a 20-minute time span.
And so, does the rule allow the landfill operator to remedy any exceedance once it's detected?
It does.
And what's that process?
The rule provides for an exceedance to be corrected within 10 days either by adjusting the wells or the collection system. If that hasn't corrected the exceedance, the rule provides for another 10-day window to do any type of maintenance to the surface of the landfill. And if that doesn't correct the exceedance, if the operator of the landfill determines that a well needs to be placed, they have another 45 days to install a well.
And so if the exceedance goes beyond the rule time limit, is what's the ultimate remedy?
They would be in non-compliance with the rule.
Okay. Can a facility be in compliance with District Rule 1150.1 and still cause an odor nuisance?
In my opinion, yes.
And have you personally reviewed the surface emission reports prepared by the landfill and submitted to the district for the last 3 years?
Yes, sir, I have.
And did you prepare a summary of your review of those surface emission reports?
I did.
I'd like you to look at what's been marked as Exhibit 30. Do you recognize that document?
I do.
Can you please describe it for us?
This is a table of information that I summarized from the quarterly reports that Sunshine Canyon Landfill submitted to the district.
And what, can you walk us through the columns on the report, please?
I have a definition of headers for the different columns. In the first column is the quarter of the report. The second column is titled Total Grids. These are all of the grids at the landfill. The entire landfill is cut up into 50,000 square foot grids. The next column are the column labeled out of bounds. This is the label in the quarterly report. These are grids that are not over waste and are not monitored. The next column is grids that are over waste. These are the grids that are over waste. The next column are the grids, the number of grids that were identified as unsafe. An unsafe grid can either be unsafe due to it currently receiving waste, it being too steep to safely traverse to do the integrated monitoring, one that is experiencing high traffic from heavy equipment, or one that has been recently hydroseeded. The next column you see is the number of grids that exceeded the 25 part per million limit for average integrated monitoring. The column after that, you'll see those are the grids that were corrected during the time frames allotted by the rule. The column after that is the maximum reading for any set of exceeded grids. And the last grid is the average approximate of the readings, average readings for those grids that we're monitoring during that time period.
And on your chart, you divided into a city and a county section?
Yes, sir.
And why is that?
Because they are in two different sections and they are reported in different sections of the quarterly report.
And so going to the far column where you have the average approximate ppm, is that the average throughout the landfill?
That is the average for the grids that were monitored.
And so when you look at that column, they're below the 25 ppm required by the rule?
Yes.
And so when you have the maximum reading, is that in certain grids within the landfill where you've had readings above the limit?
Yes.
And so how many times have they had, or to what magnitude have they had readings above the 25 ppm limit per their own monitoring?
The highest reading that was reported for a grid that exceeded was in the fourth quarter of 2013, and it was 480 parts per million average over a 50,000 square foot grid.
And so how frequent do they have exceedances above the limit throughout the landfill?
Over the course of the 3 years that I reviewed, there were 393 instances of exceedance of the rule limit.
And is that on both sections of the landfill?
Yes.
And have they repaired the exceedances within the rule required time limits?
For the majority of the grids, yes.
And do you have an opinion on whether gas is escaping from the landfill based on review of their surface emission readings?
I do.
And just for background, do you have any experience working for an LEA prior to your employment with the district?
Yes, sir, I do.
And what is your background in that employment?
In 1994, I was hired by the San Bernardino County Environmental Health Services as a local enforcement agency employee. I inspected landfills for San Bernardino County for 8 years.
And so when you looked at this data, you have an understanding of what you're looking at and how to interpret it?
Yes, sir, I do.
Okay, thank you. No further questions.
Mr. Beck?
Thank you. I just have a few questions, won't take long. You said that most of the grids that had an exceedance were corrected within the time period. Is it correct that there are actually just 2 instances on your chart where that was not the case?
Yes, sir.
And in the upper grid, which is for the city portion of the landfill, there was, the one occasion is the occasion that you've marked with an asterisk under the heading corrected?
Yes, sir.
And for that one, there were 34 grids that showed exceedances during that quarter, but that 34 grids refers to all 3 monitoring events during that quarter. Is that right?
No, sir.
Okay. Let's step back. The monitoring occurs monthly, correct?
Yes, sir.
All right. And then that's rolled up into a quarterly report.
Yes, sir.
Okay. So within the 34, could there be a single grid that had more than one exceedance?
Yes, sir.
Okay. And then what you've got is that there are 34 grids with exceedances, 30 were corrected, but you asterisk that to point out essentially the reason why it didn't need to be corrected, right?
Not, I'm sorry, sir, could you rephrase that?
Yeah, let me say it a better way. What you asterisk or what you footnoted the number under corrected to say is, quote, 4 grids were not put into compliance because at the time of recheck, they had become site of active waste disposal.
Yes, sir.
And so if they're the site of active waste disposal now, they're not in a place that you can do surface emissions monitoring.
Yes, sir.
Okay. So you couldn't go back and make the demonstration at those 4 monitoring points on that occasion.
It was unsafe to do so.
Right. And the district didn't treat that as a violation of the rule and in fact has never issued an NOV since the beginning of 2013, correct?
I don't have that information, sir.
Mr. Israel would have that.
Yes, sir.
We'll get that. I think we actually got that from him yesterday. And then just to nail down what I think is the only open question left on this chart, if you look at the 4th quarter of 2014 in the county section, that's the lower part of the graph, it's about the middle row. Do you see that there are 26 recorded exceedances, of which 23 you have shown corrected?
Yes.
And you don't presently have evidence of how or when or through what method those were corrected or whether they fell out of monitoring for some reason, you just can't explain those?
No, sir, there's no information in the reports I generated
Right.
or reviewed.
And so it would be useful if we could provide an explanation for those 3 instances.
Yes, sir.
Okay, thank you. And just to make sure you defined it accurately up here, but when you refer to an unsafe grid, you just mean it's unsafe to go do the scanning because of the topography or the land use. You're not saying it's unsafe to the public in some way.
That is correct.
Thank you.
Mr. Ravenstein, I'm looking at the top chart, and on the first row, there's total grids, there's out-of-bound grids, and there's grids over waste. If I add the out-of-bound grids on that first row to the grids over waste, I get a number different than the total grids. Why is that?
I don't know. I just wrote the numbers as they were in the report.
Ah, okay. You stated, I believe, that compliance does not mean that there is no odor, or does that mean that there's no odor nuisance? Which did you?
I expressed my opinion that the landfill being in compliance with Rule 1150.1 does not necessarily mean that they would not be in non-compliance with Rule 402.
Can you elaborate on that?
Yes, sir. Rule 1150.1 allows or provides that landfills can emit up to 25 parts per million on average over grids or the entire surface of the landfill. The gas methane that's measured during the integrated monitoring is part of the emissions that come through the surface of the landfill, and the emissions are odorous. The entire surface of the landfill is permitted to emit up to 24 parts per million of the entire surface, and these emissions include the odors. Those odors can possibly accumulate and be transported off-site.
When you said can accumulate, suppose it's 24 ppm, and as it moves off-site, are you suggesting that the concentration will be greater?
No, sir, just that the gases that are coming through the surface of the landfill don't necessarily stay in one place, but rather move.
So even at 24 ppm, there will be sufficient odorous compounds to be detected by a human being?
In my opinion.
Okay. Ms. Prusak?
Does part of your opinion that a nuisance can exist despite compliance with 1150.1 have anything to do, bless you, have anything to do with the time that is allotted in the rule to correct deficiencies as well?
Not necessarily, no, ma'am.
No, okay. So it's not that they can continue to be out of compliance for a certain period of time and then be corrected?
No, ma'am. I
Okay.
believe that even being in compliance with the rule 100% of the time, there are emissions that are allowed through the surface. We only measure the methane. We don't measure any odor portion. But in my opinion, the methane does not come through the surface unaccompanied by the odor portion.
Oh, gotcha. Thank you. I had a few other questions. The grids that are checked, well, let me just ask, you may have the same answer as you had to one of the chairman's questions. I'm looking also at at Exhibit 30, and I'm looking at the grids checked column, which is higher than the total grids column, and I'm wondering if you had an explanation for that, or...
No, ma'am, I don't.
Okay. We heard a lot about surface burping or leachate blowing through the side on occasion from the landfill at different places. Do you know, would that happen in an area that is not over trash and that is not monitored? Could there be escape of any kinds of gases out of other areas that are not monitored?
My experience with the local enforcement agency as an inspector is that gas will migrate through porous materials away from the boundaries of trash.
Okay, so then the answer is yes.
Yes, ma'am.
There could be emissions, but they're not being monitored.
That's not necessarily the case. The landfill is required to install perimeter monitoring probes to measure migration of gas off-site and out of the trash boundary. The SCAQMD does not necessarily monitor those perimeter probes.
Right, but maybe I should have asked the question better. For purposes of 1150.1, my understanding of your testimony was that only the grids over waste are checked for purposes of compliance with 1150.1, is
With
that correct?
compliance to the portion of, forgive me for interrupting, with compliance of the portion of the rule that requires integrated monitoring over the grids.
I see, okay. But there is monitoring for the instantaneous that is required not over waste?
I'm not sure. I know that the instantaneous needs to be monitored. I don't know that the rule defines where it has to be over waste or not.
Okay, okay. Just trying to understand, if all the monitoring happens on grids over waste for purposes of 1150.1, or there are other sections of the landfill that are not monitored for purposes of compliance with 1150.1, if you know the answer to
I
that.
do know the answer. 1150.1 also requires that the perimeter probes be monitored.
Okay. Did you say that there were 90 exceedances total in this time frame?
393, ma'am.
393, okay, I thought I heard that wrong. Do you know, oh, it's on here, never mind. That was it. That's the last one I asked. Thank you.
Ms. Byrd?
Just to confirm for myself, I believe that what you said as applies to Rule 1150.1 was that for exceedances, that's for your average above 25 ppm, right? That corrections have to be made within 10 days, or 10 days are given as an allowance to make corrections, and that correction allowance is for the well, for which thing are we saying it's allowed for?
Yes, ma'am. Rule 1150.1 provides for a 10-day period to correct exceedances through the adjustment of the collection system, either increasing or decreasing well capture.
Okay. And then you said that if that is not enough, then there's another 10 days for maintenance. And what would that maintenance, what would that entail?
Yes, ma'am. The maintaining the surface of the landfill can include using heavy equipment to track over the surface of the landfill in order to better prepare the surface to contain the gas. And there are several other measures like that to maintain, either fixing cracks or different measures like that.
Okay, so those are more mechanical things, not necessarily adjustments of the collection.
Yes, ma'am.
Okay. And then if that still doesn't work, then there's an additional 45 days to install a new well? Is that what you
Yes,
said?
ma'am. The rule provides for a 45-day window if the operator determines that a well is needed to be placed in order to correct the exceedance.
Okay. And not to criticize the rule, but in that period of time, we're talking 65 days of recognizing there's an exceedance to the time that there might be an actual correction that's allowed.
Yes, ma'am.
Okay. Okay. I just want to confirm. Thank you.
I think I missed something along the way. These perimeter monitors operated by Sunshine Canyon are within the landfill property, okay? And I thought you said they're not, well, you tell me, are they monitored by the district? Does the district look at the data?
Yes, the district looks at the data.
Okay. Is there evidence of off-site migration?
I'm sorry, sir, I did not review the quarterly reports for that information.
Okay. Is that something perhaps Mr. Israel might know?
I don't know.
Okay.
Just to clarify, I think the testimony yesterday from Mr. Thompson from the LEA is that they connect to those probes and then they monitor it as part of their jurisdiction over the landfill. And I believe he testified that if it comes through the surface, that's under the jurisdiction of the district. But if it stays underground and migrates, the LEA monitors that to pursue any enforcement or remediation that may be necessary.
That's correct. He did testify to that.
I guess what I didn't ask is whether they had detected off-site migration and
Mr. Thompson said they did not.
Yeah, that was
Thank
my
you.
understanding. There was no enforcement actions that had occurred.
okay. Any other questions? Thank you very much.
I'm sorry, might I
Oh.
just clear up one thing? Actually, two quick things. The reason that grids checked is the number of grids is greater than the number of grids over waste is that you check the grids more than once in a report. You check them monthly, but the report is quarterly. Isn't that right?
Oh, I apologize, yes, yes, the report reflects monthly checking of the grids. where it's a quarterly report.
And then just the last thing, and basically I'm going to compartmentalize who does what. You haven't looked at the ambient air monitoring for non-methane organic compounds that has taken place, have you?
I have not.
Okay, thank you.
If there's no further questions, thank you very much.
Yeah.
Just a second.
Sorry, just one more. I just want to follow up on what, and close this out in my head. The fact that there's 65 days, I guess. Is the correction, in your opinion, a complicated correction? I mean, normally, if you're allowed 65 days from the time that it was actually, there is an exceedance to being corrected. Is it that difficult of a process, or why 65 days, if you have an opinion?
In my opinion, it's not complicated, but it's time-consuming. Landfill operators understand their control systems, and sometimes with control systems, it can be difficult to balance a gas collection system, and so and that's why the timeframes are there.
So that's reasonable time, in your opinion?
Yes, ma'am.
Thank you.
Ms. Broussard?
You may or you may not know the answer to this, but do you know over this time period how long on average it took to correct the 393? Were some of them on the longer end? Were some of them quick? If you know, great. If you don't, it's fine.
I have a memory that most of the grids were corrected in a very short time frame. Very, very few grids required the full 65-day period to correct.
But some did.
Some did.
Okay. Thank you.
Senator?
Go ahead.
My question, so can you recollect just about how many exceeded the 65 days?
I'm sorry, sir, I can't.
That's very important to have been noted here.
To exceed the 65 days?
Or it requires 65 days. And so some of them were not put in compliance even after 65 days and have to be discarded and the wells replaced. The probes replaced.
The reports that I reviewed, there were only 3 grids that they did not have an answer as to their compliance. So those are the only 3 that I'm unsure as to their compliance status.
All right, thank you.
And just to follow up on a couple quick things that were asked. First of all, just as to this summary, this is your attempt to digest a tremendous amount of information in big reports and make it simple to see and understand. But if people want to look behind this to find particular things like how did we repair that well and how many days did it take, we could actually look at the surface emissions monitoring reports themselves.
Yes, sir.
Okay. And then with respect to the time frame for correction, just to understand how that works, in the first 10 days, and maybe even the day they discover it, the landfill operator can go out and actually tune the valve on the well to try to increase capture as long as they're not going to pull in oxygen and take some risk, and that may solve the exceedance right then, right?
Yes, sir.
And I assume out of these 386 corrections that were undertaken, quite a number of them could be done simply by adjusting the wellhead?
Yes, sir, that's possible.
Now, if you can't get it done in the first 10 days by simply adjusting the wellhead, and you actually have to physically repair the ground to improve your cover to keep in the gas, that's what they get another 10 days to accomplish?
Yes, sir.
But you're not saying that always took 20 days. It may have taken less time than that.
Yes, sir.
And then finally, if they can't stop this exceedance of the regulation within the time frame, either by tuning the well or by improving the cover in that particular area, then they have to take a look with an engineer at the question of, do I need another gas well in order to get effective capture?
Yes, sir, that's what the rule says.
And if they made the wrong decision on that, if they didn't put in a gas well that they needed, they'd be getting more surface emissions, right? You would see it show up as further problems.
Yes, sir.
But for the gas well, the reason that takes some time is that you actually have to engineer it, approve it, or get it approved by the regulator, hire a drill rig, bring them out to the site and drill the gas well and install it and make it operational?
That's my understanding, yes, sir.
And that's why that takes time in those few instances.
Yes, sir.
Thank you.
Senator?
Sir, do you have knowledge has it been indicated to you what caused the failure in many of these cases? The cause of the failure, or
No, sir.
defects?
No, sir.
Sometimes they say they make the adjustment just by turning the knob or whatever the case may be,
It's called the wellhead cylinder,
turning the wellhead,
a valve.
the valve. So it's a defect in the valve, I guess, if it required an adjustment. But you wouldn't know that.
I wouldn't know that, sir. It's my understanding of landfills, from my experience in the local enforcement agency and my time here at the district, that the trash will decompose at different rates, and the gas will move underneath the surface of the landfill and go to different portions of the landfill, and that's why there's differential emissions.
That still doesn't explain why they exceed the emission level. Even though you don't have a uniform distribution of the gas, it varies at different points and times in the grid.
Yes, sir.
But your question cannot be answered. All right, thank you.
Mr. Sanchez?
Thank you, Mr. Chairman. Mr. Ravenstein, are you familiar with the intermediate cover proposal that's in the order and being proposed at this site?
Yes, sir.
Do you have an opinion on whether application of a thicker intermediate cover at the landfill would help improve or reduce some of these exceedances?
Yes, sir.
Okay. And what is your understanding of practices at landfill to try to create a thicker cover to, I think as the senator described, capture or, reduce landfill traveling or gas not being captured by the system?
A thicker cover would be effective, but it depends on the type of material being used to cover. If the material is porous, then a thicker cover will only be marginally more effective. If the material is more clay-like or has a higher clay content, it's more easily compactable and made to be a sealant, so to speak, and hold the gas in to where it can be collected by the gas collection system.
Thank you.
One last? I need to, I think
Mr.
I need to.
Ravenstein, you're not going to get off.
I want you to, I really do. I just want to make sure one thing is brought out, and that is, you've reviewed surface emission monitoring for other landfills besides this one.
Yes, sir.
There's no landfill anywhere in this region that doesn't have surface emissions exceedances of the 25 ppm, correct?
That is correct.
Once again, thank you very much.
Thank you.
Thank you.
I'd ask that Exhibit 30 be admitted in evidence.
And we have no objection to that.
Exhibit 30 is in evidence.
And then I would just point out for the board, Exhibits 22 through 25 are the 1150.1 reports that were reviewed by Mr. Ravenstein as part of his generation of that report and the data that he compiled.
Thank you.
Did you
Ms.
say-
Broussard?
21 through 25, is that 22 through 25?
22 through 25. There may be some that I can provide electronically if they weren't copied in there, but for the most part, that's the ones that we had readily available to copy and place into our exhibit binder.
In my notebook, I have a fly page for 22. We may need to supply full copies of those if we want them in the record.
All right, thank you.
Thank you.
While Mr. Israel is coming up to the table, yesterday I asked the board members to look over their calendars for the next month, for November and December, and to let me know when they would not be available in the event we need a second Saturday hearing. I will provide that information to you after the break, and then perhaps sometime before the end of the day, we can discuss the schedule going forward. I think we have some dates all the way through December 1st, and we need to discuss whether or not we're going to need hearing dates beyond that. Okay, Mr. Sir?
Not anymore.
Okay. It evens out. Mr. Sanchez?
I think we finished off, we were about to start cross with respondents, but Mr. Israel has indicated to me he needed to make some corrections in Exhibit 29. Can you please identify for us, Mr. Israel? Are you still under oath, Mr. Israel?
Yes, I am.
Could you please identify for us any changes that you'd like to make to the report that's been marked as Exhibit 29?
The December 2013 notice of violation, the first one was issued on a Thursday. That's December 5th. I believe the paperwork reflects the incorrect date as December 7th. So the date should be December 5th, 2013.
Anything additional?
The only additional is for, and we did not discuss it, I believe you didn't have the report handy, July 2016, July 21st. In the paperwork that you have, the number of complaints that were verified were 13. That was the very last notice of violation during this period.
Anything further?
No.
Yeah, and as I indicated yesterday, we didn't discuss the last two NOVs. When I checked the documents that were provided to respondent, they were not included. I have located them, and I will provide them to them, but until they get a chance to review them, I won't have Mr. Israel discuss those last two NOVs on his chart.
Okay.
Thank you. Nothing further at this time.
Okay, Mr. Broom, questions for Mr. Israel?
Thank you, Mr. Chairman. Good morning, Mr. Israel.
Good morning.
Mr. Israel, yesterday you said that, I want to make sure I have this right, that it wasn't until the year 2011 that there were a significant number of complaints received by the Air District regarding evening landfill gas odors?
That was my recollection, yes.
So this would have been about a year after the county required the landfill to adopt the 9 inches of daily cover soil practice?
I don't recall the exact date when that was adopted. If that's what you say when it was, I don't have any independent recollection.
I think the record will show it was in 2010. I'd like to talk a little bit about Exhibit 29. And first of all, I'd like to thank you for preparing this. It's very helpful. I've done some mathematics, and I want to start with a disclaimer. There's a reason I didn't go to medical school. It's because I'm not very strong at math, so if I may be off a number on my count. But as I count this list, not counting the June and July NOVs, which Mr. Sanchez removed from the exhibit, I have a total of 93 notices of violation issued by you. Does that sound about right?
Yes.
And of those, I looked first to see how many NOVs were solely for evening landfill gas odors. And I came up with a total number of 63 NOVs, or about 2/3 of the total. Does that sound about right to you?
Yes.
And for pure morning odor NOVs, I came up with a total of 12. Does that sound about right?
Just morning or,
Just morning, not a combination of morning and evening, but purely morning odor complaints. I came up with a total of 12 NOVs.
well, I didn't go in and count them, but that sounds reasonable, sure.
And then finally, I think to answer your last question, I came up with a total of 17 hybrid NOVs, which involved both morning and evening odor complaints, to come up with a total of 93 notices of violation. So that's,
Sure.
those numbers sound about right? Okay, thank you. So what I'd like to spend some time talking about this morning are the evening notices of violation for evening landfill gas odors. And I believe you testified yesterday that typically the complaints for evening landfill gas odors were received by the district roughly between the hours of 8 p.m. and midnight, as a general rule?
Well, I don't want to say as a general rule, because the information that's provided on this document is when I verified the odor complaints. Some of these odor complaints may have come in a couple hours before. So we'd have to go through the entire data log to see when all these complaints came in. But in a general sense, they're probably within an hour from the time that I arrived at the residential location when they would have been received.
And when you receive a complaint, when that is the Air District receives a complaint, you note it in your summary write-up when you issue an NOV as to the exact time that the Air District received the complaint from a complainant?
That's correct, and there are also the actual document that's generated, complaint document is also included.
I believe you testified yesterday that there were primarily a few streets from which most of the odor complaints for evening landfill gas odors claim. And I just want to check my notes and make sure they're accurate. I think you said that most of the complaints came from Canyon Ridge?
Well, I didn't say any specific street. What the document says is the different streets. Canyon Ridge is one of several streets where complaints are typically received in the evening hours.
And the other streets that were primarily the streets from which evening landfill gas odor complaints came in were from Golden Valley Lane and Mission Tierra Way cul-de-sac?
And Mission Tierra Way, correct.
Okay, thank you. And I believe you also said that in counting the required minimum number of verified odor complaints for residential premises, a household counted as one complaint?
That's correct.
So if 3 people in the same home complain, that's still just one complaint?
That's correct.
And typically, did you receive more than one person complaining from the same address?
Not typically, no.
And I believe you testified yesterday that there were approximately 6 to 10 people who called in much more frequently than others?
Well, I don't remember saying that there were specific individuals, but I think more in line with what I said was the street locations. I didn't talk about specific individuals.
Right. Mr. Chairman, I'm going to ask Mr. Israel about some specific names, and I just want to clarify for the record before I do so that the people I'm going to be asking about, except for one, are all on the Air District's witness list. Some of them have already testified, so their names will be part of this record, names and addresses. And therefore, and we also have independent information regarding these individuals from the class action litigation. So I'm not using these names in violation of the protective order. I'm not using their names as a result of the disclosure of the notice of violation files we received from the district pursuant to the protective order. And I mentioned this to Mr. Sanchez yesterday. And the other individuals I'm going to be talking about are 2 brothers who have moved away from the area who were the lead plaintiffs in the class action lawsuit. So they're no longer at the address they used to live at in the area. And their names and addresses are a matter of public record because they're in the complaint that was filed in the Superior Court for Los Angeles County. So I just want to make sure that that the board understands that in asking about some specific individuals, I won't be violating the terms of the board's protective order.
Mr. Sanchez, you know the names of the individuals that Mr. Bruin is going to mention?
He had mentioned to me that they would be on our witness list. He didn't give me the specific names. Maybe if he has a list, that may be helpful.
I'm happy to show him my list.
Would you do so, Ms. Prusak?
I just want to ask one clarifying question, too. You mentioned all but one are on that list. Is the one the brothers that you were just talking about who
Yes.
are, as a matter of public record, on the litigation?
Correct. Yes, and I should say that they also testified before this hearing board and gave their names, and one of them gave their name and address during the proceedings in December of 2011.
Senator, did you have comment?
This one individual, in what way is he or she associated with this case at all?
Well,
Why do you think you made a distinction between that individual and the others who were directly related in some way, a greater extent with the case?
Well, I believe these people who've moved away aren't testifying in this proceeding. I think that's the distinction, but they're otherwise very much involved in the notices of violation issued by the district, and they were the leaders, so to speak, of the class action litigation and have made a number of complaints.
Is that one individual involved in the class action?
Well, there's more than one individual.
That was the one you set aside from the others. You said there's one individual would not be put in any specific category of people that you would be inviting.
I'm not sure I understand your question, but there are other people who will be testifying who are on the district's exhibit list who are also involved in the class action. Some of them are named plaintiffs. So the class action, there are actually 6 individuals who are plaintiffs in that case. But 2 of them are the brothers who lived in this one home who've moved out of the neighborhood.
But, I mean, sometime I heard you say the class action suit has been settled.
Well, it's almost settled.
You said that 3 months ago.
Well, if I may explain. We have a settlement that was reached as a result of a mediation. We're in the process of finalizing the paperwork. We hope to have a motion filed with the Superior Court hopefully within a week or 2. We have a date set by the Superior Court judge for approval of the settlement, which is December 1. So the case is not formally settled until the court gives preliminary approval of the settlement, and then there's a period of time in which the class gets notification through the court process, and then there's a final approval hearing. It's really not until the final approval hearing that the ink is dried, so to speak, on the document, and it's finally settled. But as a practical matter, there is a settlement right now as a result of that mediation.
Yes, sir, but you initially requested through Freedom of Information to acquire the names of these individuals involved in who testified before this board at one time or another. And I think you took it to the court, and the court denied that request. And the district, for whatever reason, said they would provide the information to you. Not required by the court to do that either, which baffled me to some degree.
Well, if I can clarify, Senator, the names of the 2 brothers we've had for years. We had long before the documents were produced by the district pursuant to the subpoena, because again, they were the lead plaintiffs in this lawsuit, which was filed several years ago.
Mr. Bruin, but you also stated, and I like things to be on the table and be up front. Double talk confuses me. I asked you 3 months ago, after you stated this case is settled in the Valley, in the public meeting. I said, okay, fine. And then you were requesting this information through the Freedom of Information Act. And it bothers me that then you came here and testified when you provided the information. I mean, you came in and made a statement that you're going to settle again. I said, well, I thought you already settled. Now today you're saying you're still in the process of settling this case 3 months afterwards.
Well,
Ms. Prusak?
I would like to have the list given to Mr. Sanchez prior to us hearing any names publicly as part of this proceeding. I tend to feel that it's not an issue for someone who's actually on the list, because you have a right to a defense. I do potentially have an issue as to the last person, even if that person was part of a separate litigation, because that person no longer lives here, and I don't know if that person had notice of this proceeding. And so I'll leave that to the attorneys to explain to the board, but in the meantime, I'd like for Mr. Sanchez to review the list.
We're going to take a recess, give Mr. Sanchez an opportunity to review that list. And also during that time, I ask my fellow board members to provide me any Saturday dates when they will not be available in the next 2 months. We're in recess until 10:25.
I'm sorry, through what date are we looking at?
We're back on the record. Mr. Sanchez,
Mr. Chairman, before you go to Mr. Sanchez, I just want to make one final statement as I was talking to Mr. Broom.
I wasn't going to do that. I was going to
Fine.
tell the parties what days this board is available or not available, and then we can do that.
Okay.
So you all know we do have this Saturday, November 5, has already been scheduled. The following Saturdays are available at this point, and that is Saturday, November 12th, Saturday, December 10th, and Saturday, December 17th. So that's 3 Saturdays. If needed, and we hope they're not needed, and if there's no other choice, 2 board members would not like to be present on the 3rd of December, a Saturday, but can make themselves available if absolutely necessary.
I'm sorry, which Saturday is that the least?
December 3rd.
Oh, December 3rd, got it.
So we have November 12th, December 10th, December 17th, and December 3rd if absolutely necessary.
Yeah, the parties continue to try to find a solution to keep this hearing limited to that one Saturday. You know, we are exploring all options. The district continues to remain in communication with the witnesses from the public identified on our list to, you know, get them to try to come during the week. Obviously it is difficult, but we remain committed to try to keep this process as efficient as possible.
And we also have suggested the possibility of simply stipulating what some of the public witnesses would say, that they would testify in accordance with their complaints, if that will help us reduce the number that the district feels it needs to call, and that's under consideration also.
Thank you. Also, we had previously set aside November 1st as a day when the board would hear other matters in the event they came up. It turns out now that one matter that had been previously scheduled for November 1st is now off calendar. So unless there's an emergency variance filed today or tomorrow, November 1st will be available if the parties can make use of that date. That's Tuesday of next week.
I've kind of scheduled around that date. What I had shared with respondents in the hallway was to try to have all our remaining witnesses on November 2nd and perhaps not need the 3rd. I would like to not proceed on November 1st at this time, but I do understand respondents are probably in town anyways.
Now, we're fine starting on the 2nd, and if you think you can get done on the 2nd, that'd be great.
So I will keep everyone apprised of trying to eliminate the 3rd if possible.
Appreciate that. Okay. Now,
Yeah, Mr. Chairman, Mr. Bruin, I've voted in some matters on this, regarding this case already, and with the representation that you provided, that your case lawsuit is being settled, or about to be settled, and then my feeling at that point in time, that no matter what we did here, would not contribute to the outcome of that case in any way. But if it's still dragging on, and I don't know the status, nor does any other member here know the status of that case, not really, only based on what you say. And if it turns out that there's your opponent have reason to believe that we provided information to you that the court didn't provide, or advantage you in some way, doing whatever discovery they can come up with, they can ask me or anyone else why we were involved or why we voted a certain way when we would have voted another had we known that this case is still ongoing.
Would you like me to respond?
Yes, sir.
The case has settled. We went to a mediation before a retired judge, Tim McCoy, Superior Court judge. We have a term sheet. It's in writing. Council have agreed to it. We have exchanged drafts of the settlement agreement. It's being reviewed by the plaintiffs right now. We expect a motion for preliminary court approval to be filed within the next 7 to 10 days. So when I say as a lawyer that a case is settled, what I mean is it's settled. We've resolved this matter. There is a process that by law we have to go through with the Superior Court to get court approval of the settlement. There's always a chance a court could refuse a settlement, but we're quite confident here that because the settlement is the result of a mediation before Judge McCoy, that the judge in our case, Judge Freeman, is going to approve this settlement. So I don't think we've made any misrepresentation to this board as to the status of the case. So far as we're concerned, the matter is settled.
So both sides agreed to the settlement and mediation?
Yes.
All right.
And if I might, Mr. Chairman, in my own defense, I'm looking actually at the hearing from the August 31st public meeting. Oh, sorry, thank you. Just in my own behalf, I'm looking at the transcript from the August 31st public meeting or public hearing because I want to confirm what I said. And I did say that the case had been settled, that we were working on the draft paperwork to implement the settlement, and that there were further procedures required before that would occur. That is still true. It's taken longer than we had hoped because there's been a lot of back and forth, but it's in exactly that status. It was settled in June. It does require court approval because it's a class action, and it's a class action settlement, and we are finishing up the paperwork. We hope we have it done, but we're waiting to hear from the lawyers representing the class, the settlement class, that they approve the final version.
thank you. I think the board understands the status of that settlement now. Appreciate it.
Thank you.
Okay, now, Mr. Bruin was going to, you've shared the list with Mr. Sanchez. Mr. Sanchez has reviewed the list, and there's no issue.
The solution that we've proposed is because two of the individuals are not on the witness list, but are plaintiffs in the class action lawsuit. We will only refer to them on the record as Plaintiff 1 and Plaintiff 2. And then one individual who is on our witness list, but as indicated, will not be able to attend the November 5th hearing, but has indicated that they will submit a letter covering their experience in lieu of testimony. That for now, we will identify that individual as witness 1. If that letter is submitted into the record and the details are consistent with what was going to be presented and they identify themselves as a complainant, we would then identify that person on the record once they've made themselves publicly available through their own submission of testimony. The district doesn't have an objection because we've identified the other people as appearing to testify on the November 5th hearing.
Thank you. Mr. Bruin, you may proceed.
Thank you, Mr. Chairman. So, Mr. Israel, may seem like a strange question, but when I refer to Plaintiff 1 and Plaintiff 2, you know who I'm referring to?
I'm not going to guess. I'm,
No, I thought Mr. Sanchez had informed you.
yes, I know who it is.
And
they
when
are.
I refer to witness 1, you know who I'm referring to?
Yes.
Okay, all right. So, now, Plaintiff 1 and Plaintiff 2 moved out of the Granada Hills area in this year, 2016? Is that your knowledge?
That's correct.
Right. Before they moved out, is it true that Plaintiff 1 and Plaintiff 2, two brothers who lived in a home in the area, were responsible for calling in 25% of all complaints regarding evening landfill gas odors that were called into the air district?
Well, I don't know the percentage, but it was a lot.
Well, you had your deposition taken in the class action lawsuit in 2014, is that right?
2014 or 2013? It sounds about right.
And at that time, didn't you say that they were responsible for about 25% of all complaints called in?
Well, I don't recall if I gave a percentage on it.
But does that sound accurate?
They call a lot. I mean, they call quite a bit,
But
yes.
Would 25% be a fair estimate in your mind?
You know, I don't want to say yes or no because I'd have to look at all the numbers or all the times that they complained. I mean, they complained a fair enough amount, yes.
Okay.
But I can't say 25%, 30%, 40%, or anything like that.
It could be somewhere in that range.
It could be.
All right. Now, of the 63 evening NOVs, and this is my math again, subject to the disclaimer I gave earlier, but by my count, a verified of the 63 NOVs, 55 of them were based in part on verified complaints from either Plaintiff 1 or Plaintiff 2. 55 of the 63. Does that sound right to you?
You know, I don't want to say because that's your math. Half the NOVs that I wrote, when I write the NOV report, you know, I make a note of obviously who's complaining, but I don't keep track of, well, this is the same person who's called, and so therefore, out of 10 NOVs I've written, they've called 10 times. I just don't do that. If that's what you've looked at and you've determined as being a number, I'm not going to disagree with it. I'm not going to agree with it. All I'm going to say is that a lot of the notices of violation for the evening hours involved those individuals, yes.
And would the same be true of Ellie Katoyan?
Well, again, she calls a lot, and I verify it and have written notices of violation based upon affidavits that she signed. She's called a lot. I really don't have specific numbers. I don't do things like that.
All right.
What's the spelling of that name?
Kotoyan.
That's listed as exhibit number, witness number 25 on the exhibit list filed by petitioners.
Thank you.
So let me just go through these numbers quickly, Mr. Israel. I don't want to be unfair to you. I know you don't have the exact counts, but I'll give you my count, and you can let me know if they sound right or wrong, or if you're just not sure. But by my count of the 63 evening landfill gas NOVs, they were based in part on verified complaints from Ellie Katoyan, 56 complaints, Roxy Dukmajian, 53 complaints, Witness 1, 43 complaints, Andrea Provenzal, who testified at the first public hearing, 37 complaints, Andy Chesler, 33 complaints, Vatch, V-A-T-C-H-E, Katsumian, K-A-T-S-U-M-Y-A-N, 30 complaints. And finally, McVoke, who testified at the public hearing, 27 complaints. So do those frequency of verified complaints leading up to those 63 evening landfill gas odor NOVs sound about right to you, or are you unable to say?
Well, what I will say is that those individuals complain a lot, and I have verified odors at each of those residents with those individuals quite a number of times. I don't have the specific number of times,
All
but
right.
that seems reasonable.
Okay. I believe you testified yesterday that in your practice, you required 6 verified complaints before you'll issue an NOV for evening landfill gas odors?
That is the district's policy, yes.
And if you were not to count the people I've named, including plaintiff 1 and 2 and witness 1, is it fair to say that you wouldn't have issued any NOVs for evening landfill gas odors during the last 3 years because you needed complaints from those folks to obtain a minimum of 6 verified complaints?
Well, I wouldn't say that exactly. There are a number of times that there were more than 6 complaints in the evening hours, some as high as 10 or more. Those individuals were a part of that. Whether or not some of the notices of violation wouldn't have been issued without having any or all of them, that is quite possible. I don't want to speculate as to I wouldn't have issued any. I believe that I would have. I believe that the numbers speak for themselves and the complaints speak for themselves. But that's how I would answer that.
Okay, thank you. And you haven't done that type of analysis of your own notices of violation, right?
No, I do not.
Okay, well, we can provide that data as part of our case. I'd like you to turn, if you would, to Respondents Exhibit H. This is in the black binder that should be on the dais of each of the hearing board members. We're going to put that on the screen as well. Wow. Mr. Chairman, our paralegal just corrected the spelling of Mr. I said his last name was Katsumian. There's no T. It's K-A-S-U-M-Y-A-N for the record. Mr. Israel, do you have Exhibit H in front of you?
I do.
Can you tell us what this is?
This is reading from the document, the South Coast Air Quality Management District odor classification. It's a listing that classifies odor complaints by intensity. And then there's a description of that corresponds to the classification.
Is this odor classification chart official policy of the South Coast Air Quality Management District?
I don't know if I can answer it as official policy. It is something that we use and find very useful as inspectors.
Now, when you go out into the field to verify an odor complaint, it's your practice to go to each complainant's home, and when you verify the complaint, you write down in your notes how strong the odor is using the definitions in this odor classification chart?
Yes, for consistency, I do.
So when you use, when you say that you confirmed an odor complaint, say at plaintiff one's house, and that the odor was faint, and you say that in your NOV summary, the word faint, as you use it in your summary, is intended to mean the definition that we're looking at here in Exhibit H?
Yes.
And the same for all the other references you use, such as distinct, strong, or very faint?
Yes.
And in Exhibit 29, when you refer to odors being very faint or distinct, again, you're using the same definitions in this Exhibit H?
Exhibit 29 would be the summary that I prepared.
Yes.
Yes.
Okay, thank you. Now, in going through all of the evening landfill gas odor NOVs and looking at the odors you confirmed for each of the verified complaints, by my count, in 30% of the cases, you rated the odor as being distinct, and in 70% of the cases, you rated the odor as being either faint or very faint. Does that sound about right to you?
Well, having gone through each one of these, there were a number of times where it was distinct. There are a number of times that it was faint or very faint, for that matter. I don't know what percentage there is, but that doesn't sound unreasonable.
All right. Well, we can provide the specifics to the hearing board during our case. If you look at this chart, it defines a strong odor as an odor that would force itself upon the attention and that might make the air very unpleasant. And then in parentheses, it says, a probable nuisance if found in inhabited areas, end paren. And with respect to the evening landfill gas odors at Sunshine Canyon, there was less than 1% of the time that you rated any of the evening landfill gas odors as strong. Is that true?
There were a few times that it was strong, but it wasn't the majority of times, correct?
And the classification chart defines distinct as an odor of moderate intensity that would be readily detected and might be regarded with disfavor. And then it says in parentheses, a possible nuisance in inhabited areas, end quote. And again, that's the definition you use when you have rated evening odors as distinct.
Well, I think when I look at this, to me, I'm looking at really the first part of this. For example, very faint, ordinarily not noticed, faint, odor so weak the average person might not detect it. I'm looking at it from my standpoint. I don't really consider or read all the little fine print here. A possible nuisance is inhibited because a public nuisance violation is not really based on intensity. If I detect an odor, no matter how faint it is, and I verify the odor with individual complainants, the odor is traced to the source, in this case, Sunshine Canyon Landfill. All other sources are eliminated. We consider the wind direction, and most importantly, each of the individuals fill out complaint forms. That's what constitutes a notice of violation. I'm going out there, and if I can readily detect the odor, in my opinion, using this scale or this classification, to me it's distinct. If it's something that I need to really strain to smell, but it's there, I would consider that very faint. But to go through the description here in complete detail and analyze that they've written a possible nuisance in inhabited areas under distinct or a probable under strong, that's not how I was trained, and that's not what I consider to be paramount to establishing a public nuisance violation for odors.
So if someone registers an odor complaint with the district and you go to that person's house and you have to really strain to smell the odor, but you feel that you do smell something, you'll confirm that odor complaint?
There are times where I've written very faint there, that is true. But again, that odor was detected and traced back to the landfill, and the complainant completed a complaint form.
Is there a minimum duration at which an odor must be present for you to confirm an odor complaint?
No.
So it could be you get a very faint odor that lasts for 2 seconds and you would confirm that odor complaint?
Well, if you're asking me if I notice it for 2 seconds, I would say that's fleeting. I don't write notices of violation for fleeting odors. The odor complaints that I verify consistently out in that community that result in notices of violation do not last 2 seconds. I can't say they last 20 minutes or 2 hours, but during the time frame of my odor investigation is the time that I am noticing the odors in the area, and it's not for less than 2 minutes.
All right. And so is that the minimum duration that the odor must last for 2 minutes before you verify an odor complaint?
Well, I don't know where that's coming from because there is no minimum duration in a public nuisance, even in the definition of public nuisance. So I don't want to put a time frame on it. I only want to focus on what I experienced during the times that I'm investigating the odor complaints.
When you've been out in the area investigating odor complaints, have you ever had the occasion where you got a whiff of something you thought was landfill gas, but it was only momentary and then just passed?
Yes.
And when you got a whiff that was momentary at a person's house, would you confirm an odor complaint or not confirm an odor complaint?
I don't believe if I caught a whiff of something that would be what I would say I'm verifying an odor. If I catch something for a second and then it's gone, no, I would not consider that to be verified.
So what I'm trying to get at is there some minimum period that you use in practice before you'll treat an odor complaint as confirmed when you're smelling something? Is it a minute, is it 2 minutes, 5 minutes? What's your practice?
Well, what our policy is that we verify odors at each individual complaint location. So what I've tried to do on this document and what I try to do, or what I do in practice in my report, is give you the time frame when I verify the odors in the community. So if I'm verifying odors for an hour, that is not 2 minutes, or that's not a fleeting odor. That's being verified in different locations in that time frame that I'm investigating or conducting surveillance.
But I believe if you look at your NOV summaries, you typically will describe yourself as driving around, and in some areas you smell no odors, and other areas you do smell odors. Is that true?
Correct. That's part of the surveillance process.
So I guess what I'm getting at is if you're at a person's home and you're going to verify that person's odor complaint, how long do you need to be there to continually smell the odor before you'll verify that complaint? I'm trying to find out what your practice is.
Well, generally when I arrive at the complaint location, I'm detecting the odor the moment I get out of my car. And I meet with the complainant, we're verifying the odor. I have to verify in those instances if the individual is available. My practice is to obviously meet that person and verify the odor right then and there. Sometimes the person may not be available or they're asleep. As long as I'm at their location and I'm detecting the odor, I'm not going to spend any longer than I have to, other than just verifying the odor, interviewing the individual, and going up to the next complainant's address.
And typically, how long does that take?
It may take 8 to 10 minutes, it may take less than 5 minutes, but typically it's between 5 to 10 minutes at each complaint location.
Have you ever had the situation where you went to a person's home, got out of your car, smelled an odor, and while you were talking to them, the odor went away?
Well, yeah, that happens.
And do you still verify the complaint in that circumstance?
No, my practice would be no. If I smell the odor for a moment and then it's gone, I would not consider that to be part of a public nuisance violation. Generally, and we go on this all the time, we get a lot of complaints and we get out there and the odors are just for a second and they're gone or they're not at all. And that would not necessarily be part of the public nuisance violation.
What do you mean, not necessarily?
Well, that would not be part of the public nuisance violation. So, for example, I may have responded to 12 complaints on a given day, and only 10 of those were verified. And the ones that were not verified were because at that street location or that location, I did not detect anything, or if there was an odor, it was faint and fleeting enough where I couldn't verify it after a few seconds.
Okay. So let's say you went out to the community and there was a very faint odor of evening landfill gas that lasted for only an hour. In that circumstance, if you had 6 complaints, you would verify those 6 complaints?
If in fact I verified in that hour period at all 6 locations and went upwind and downwind and traced it back to the landfill and verified odors there, and each of these individuals completed complaint forms, yes, that would be a public nuisance violation.
And how long does it typically take you to go to each complainant's home and verify odors in a given evening?
Yeah, in a given evening, that could take as little as 45 minutes to an hour or several hours, depending on the number of complaints we receive. So typically, we'll spend less than 10 minutes at each complaint location. I don't like to put numbers on that because I don't like to hurry people. Sometimes people don't answer the door right away, or I need to call them or contact them depending on the hour. They would come out, we would verify the odor. There's maybe information they want to provide me about something related to what they're concerned about. So for me to put a time frame on, I would say a fair enough time frame would be 10 minutes per complaint location. So if we have 6 complaints, that's an hour. So I would be in the community at least 1 hour, and then I would go do my upwind and downwind survey, which obviously would take more time.
Okay. Now, you've already testified that it takes a minimum of 6 verified complaints before you'll issue a notice of violation for public nuisance. Now, is it true that if you were to require that the odors you verified at each home be at least distinct or stronger in intensity, that instead of issuing 63 notices of violation for evening landfill gas odors, you would have only issued 6?
Well, I think if I was to go through all my 90-plus NOVs and pick out all the ones where it's very faint to faint or just distinct, it would diminish them by quite a number, yes.
Thank you. Now, you said that with respect to Exhibit H, you didn't pay attention to the fine print regarding whether an odor might be a nuisance or not. But I would like to go to the definition of faint for just a moment. And it reads, quote, "An odor so weak that the average person might detect it if his or her attention were called to it, but that would not otherwise attract his or so attention." His or her attention. And that's the definition for faint. It doesn't say in this odor classification chart that a faint odor is a possible nuisance, correct?
It does not say that.
Did you ever speak to anybody in management at the Air District to determine if it was the Air District's policy that, despite the language in this odor classification chart, a faint odor could be the basis for a public nuisance?
Well, I don't think there's any official policy that I'm aware of where intensity is looked upon as the basis for not issuing a notice of violation for public nuisance. We simply use this classification as a guide for us. Most complainants call in, and this is clear in my reports, state that the odors, although at the time I'm with them might be faint, were much stronger or much more distinct when they called in the complaint. So I'm using, as an inspector, this classification merely as a guide to express what I'm detecting at the time that I'm interfacing with the complainant in the field, investigating the odor complaint.
Well, I think you just said that there's no policy of the Air District that says you can't issue a public nuisance NOV for an odor that is faint. But my question is a little different. Is there a policy you're aware of, either verbal or written, that says that you can or should issue a notice of violation for a faint odor?
No, I'm not aware of that.
Would the same be true for a very faint odor? You're not aware of any policy of the district that says that a notice of violation can or should be issued for an odor that is very faint?
No, I'm not aware of any official policy with the district.
Did you ever have a conversation with anybody at the management of the South Coast Air District in which they said, even if an odor is only faint or very faint, if you confirm six complaints based on very faint or faint odors, you should issue an NOV?
Well, I would say that that question is probably turned up in the course of investigating odor complaints. I can't recall a specific conversation with the manager. The conversations that I would have when it comes to my investigations into public nuisances and intensity of odors has usually been my immediate supervisor or my senior supervisor.
And can you name any names of people who have said that you should issue an NOV for odors that are very faint or faint?
Well, I don't want to, I can give you names of my supervisors, but I don't want to put words in their mouth that that's something that was exactly discussed in those words.
So in making a decision to issue a notice of violation for very faint or faint odors, that was something that you felt was within your discretion?
Well, we have to verify an odor, and to me, to establish a public nuisance, it does not matter the intensity. It matters that there is an odor that we're able to detect and verify with the complainant, and that the complainant completes a complaint form. There's no discussion on intensity in any of our policies.
So just let me ask you a hypothetical then, just to make sure I understand your understanding of the district's rules. If 6 people who live near Los Angeles International Airport said there's a really strong odor of jet fuel exhaust in the air, and you went there and you detected a very faint odor, defined as an odor that would ordinarily not be noticed by the average person, but could be detected by the experienced inspector or a very sensitive individual. If you went to the homes of those 6 individuals and got a very faint odor of jet fuel exhaust, would you issue an NOV to LAX?
Objection, too general.
I think it's a fair question.
Ms. Brissett?
I think well, I'm going to let Mr. Israel tell us why or why not that may or may not be too general, and if he can answer it, because there may be facts that are not involved in that hypothetical that would be necessary.
Well, again, intensity doesn't matter to the inspector. What matters is, do we smell an odor? Is the odor traceable to a specific source? It's verified with complainants. The complainants complete complaint forms. That constitutes a notice of violation.
So if all that were to happen in my LAX hypothetical, you'd issue an NOV?
Yes.
So let's talk about how you go about responding to odor complaints. You receive an odor complaint, I believe, through email or text, is that right?
Either email, text, well, generally not text, email or telephone. Most likely, well, it depends on the time of day, so if you phrase it differently, I can probably elaborate on that.
All right, well, just so we're clear, I'm asking you questions this morning just about evening landfill gas odors, so I'm not talking about the morning odor issue at Van Gogh. I'm just trying to get a handle on what the practice is regarding
Sure.
evening landfill gas odors.
It would be a telephone call.
All right, so you get a call from your supervisor, and your supervisor would tell you who's complained, what time of day it is, what time they complained to the air district, and what their address is, and you'd write that in your notes?
Yeah, generally what they'll do is they'll forward me the voicemail at times, and it's from the standby supervisor, which is, they're on a rotation. So at the time, I'll only be notified when the third call within an hour has been received by the standby supervisor. And then I would respond.
Okay.
And it's almost always a phone call.
And we've already testified that you receive a lot of complaints from the same people. So when you go out there and you meet with someone who's complaining about evening landfill odors, your practice is to get out of your car, go to the front door and knock on the front door, and they come to the front door?
Depending on the time of day, some people, I'm very mindful of walking up to somebody's house when it's all dark and ringing the doorbell at 10 o'clock at night. So there are times where I will call that individual. There are other individuals who we responded enough to that we will knock on their door and not necessarily call them. But again, it depends on the hour and it depends on the individual.
But in any event, you end up meeting with a complainant in order to verify their complaint, right?
Correct.
And so what is the scenario? Are you standing in their kitchen? Are you standing in their front yard? How does that work?
Well, I park on the street, so I would be detecting odors on the street. Then I would walk up to the front porch, knock on the door, and the complainant would greet me and either come out. Sometimes they invite me in. They're not comfortable standing out on the porch to discuss things depending on the time of day. It really depends, but for the most part, they come to the door and come outside.
And do you ask them to come outside, typically?
No, well, I should answer that yes and no. If I'm detecting an odor on the sidewalk, I would want them to come with me to make sure we're smelling the same thing. And so I would not want them to be in a location where if odors are trapped, they might have been there for quite a while. I would rather them come to where I'm out in the open air and see if we're detecting any odors at that point.
Okay. So when you are talking to these people, let's say you're in the front yard, do you tell them whether or not you smell anything?
Well, I ask them, are you detecting anything? Well, I'm smelling this right now. Well, I would have a conversation with them, yes.
Okay. So essentially, you let them know whether you're going to verify their odor complaint or not.
Well, there are times where they'll tell me, I'm smelling a horrible odor right now. Well, I wouldn't use horrible as the word. I'm detecting an odor right now, and I say, I'm not smelling an odor right now. And I have no explanation for that. And then there's many times where we're both detecting an odor. Maybe I would categorize it as faint to very faint. They might characterize it a little stronger. Each individual is different. Each individual have certain levels of sensitivity. And I don't question, well, I don't think you're smelling that correctly or anything like that. I just document what they describe it as and what I detected and describe it as.
How do people react when you tell them that you don't smell anything when they say they do smell something?
Well, they don't yell at me and say, you're crazy, I'm smelling the worst thing in the world right now. Generally, what I'll hear is, you should have been here a half hour ago or 2 hours ago when I called, because it was so strong it would knock you over. And how does one respond to that? Odors are very transient, and this happens more often than not, where I don't detect it as the same intensity or much less intensity that they do. But for notices of violation purposes, obviously, we're both detecting an odor. So I don't know if that answers it the way.
Well, I guess what I'm getting at is maybe people don't yell at you or tell you you're crazy, but do they seem upset sometimes?
Well, it depends on the person, too. You know, they've taken time out of their day to call the district. They're being barraged by an odor. They're obviously looking to us to verify it. If we don't verify it, you know, you're complaining about something and it's not being verified, nobody's going to be real happy about that.
Understood.
But it's a lot of it is public relations.
Sure. What do you mean it's public relations?
Pardon?
You said it's public relations. What do you mean by that?
Well, we try to listen to what they say and, you know, just have a conversation, a communication with them, rather than just being in denial. If we don't smell anything, just say, look, you know, I understand, you know, you smelt the odor. Sorry, it took us a while to get out here, but, you know, we'll do surveillance, and if the odor comes back, I mean, we'll be in touch.
Okay,
So,
understood. Now, since you do have a lot of the same people who complain fairly frequently, I take it you've gotten to know some of these people pretty well?
well, more than just the casual conversation, yes.
And you're typically on a first-name basis with these people?
Yes.
And when you're talking to them in evenings, either when you're verifying an odor complaint or meeting with them again to fill out a declaration, from time to time you share information with them about your family or your interests, things of that nature? Water cooler talk, the kind of talk you'd have in an office with coworkers?
Well, we have, you know, we're all human, so we don't want to just talk about odors all the time. But if we have that type of conversation, it's more after the odors have been verified, when I'm doing follow-up, filling out complaint forms, when there's a little more time spent to complete complaint forms, and the conversation may include other things.
So, for example, in the case of Plaintiff 1, you've had a chance to talk about his interests and what he does for a living.
Oh, yes.
And so these are fairly relaxed, casual, informal conversations.
Well, it depends which conversation you're talking about. Again, I would qualify that if it's during a complaint investigation or it's during the follow-up to complete a complaint form.
All right. And when you meet with folks and you're verifying odor complaints, is it true that you tell people who are complaining to call the air district if they smell anything?
The conversation is, call the air district if you smell an odor that is a nuisance to you.
All right. So you don't tell them it has to be a certain intensity or how strong it has to be?
No, I don't talk about intensity with complainants.
If you tell someone to call the air district if they smell something that's a nuisance to them, do you describe to them what a nuisance is or what the elements of a nuisance are?
Well, I think everybody in the community up there that has gone through this for as many years knows the type of odors that is a nuisance to them and when they're going to call. It doesn't really warrant me telling them to call the district the next time they smell an odor unless it's somebody brand new who doesn't know the process.
All right. In the course of your conversations, is it true that you told one person that you love all the calls in the evening because you get lots of overtime?
No.
I'm not going to mark this as an exhibit just yet, Mr. Chairman, but I want to show the witness a document to see if this will refresh his recollection. Mr. Israel, I would direct your attention to the highlighted area of this email, which is dated August 31, 2012.
Yes.
And there's a reference in this email from an individual I will not name saying Larry does not live in the area. He told me he loves all the calls because he gets lots of overtime, end quote. Did you make that statement to this individual in August of 2012?
No.
Do you know how this individual happened to know that you got overtime when you came out in the evening to respond to odor complaints?
Well, I would surmise that they probably asked me if we get paid to come out at such a late hour. And in the course of the conversation, yes, it is on overtime.
So isn't it possible you said you like the overtime or you don't mind it or it's good or whatever?
Well, I probably would have said that I'm out on overtime. That's the policy of the district when you respond after hours. I'm not going to, I don't recall specifically telling this individual, well, I love coming out away from my family in the middle of the night and taking time off when I could be doing a lot of other things that I'd rather be doing. If they wish to put out an email that has this information on it to people, I have no control over that.
All right, thank you. You're aware of something called the Google Group in the neighborhood near the landfill?
Well, I don't really know the name of the group that you're referring to, Google Group or whatever, so you'll have to explain exactly to me what that means.
Well, you're aware that there's a group called Stop the Granada Hills Dump?
Well, I've heard of the name, but whether I know too much about that, I've heard of the name.
And you've received some emails from that group?
I recall maybe receiving one or two, or maybe a little more emails from one in particular individual, but that individual may have sent me the email just for information. I don't correspond with any of those individuals, so if they send me an email, I might have received one. I seem to recall receiving, but it's nothing that I do any follow-up with or anything like that.
Okay. So were you aware that neighbors were using this website or this email address to communicate with one another about evening landfill gas odors?
Well, I'm aware of that because they tell me that they sent an email to other complainants. That happens in a lot of different sites. That's not unusual for just this one.
All right. And what have people told you about that?
What I've heard directly from people is that, yeah, we put out there that there's odor complaints. That's all.
Well, have people told you that they received email notices to go outside of their homes and smell odors at night so they can call the air district if they smell anything?
Well, I would say that I don't know the details of their correspondences. I think you'd have to ask them. When somebody says they put out an email that they're noticing an odor, that's all I'm privy to. I don't ask any further questions with respect to that. I would only merely respond to complaints that we received and I'm assigned through my supervisor.
But people have told you when you're verifying odor complaints that they've put out an email saying that they've smelled an odor and they've sent the email to their neighbors?
Well, I don't know who they put out the email to. I've been told that they put out an email, and they may even mention some names, but I only respond to complaints that we receive, so they can put out all the emails that they like. It doesn't mean anything. It doesn't impact my investigation in the least bit.
You were asked yesterday if people in the community are aware of the fact that there was a rule of the Air District that you needed to receive 3 complaints in a 1-hour period in order to respond to complaints in the neighborhood?
Yes.
And Mr. Sanchez asked you a question, which I wrote down, I hope this is accurate, which was, do you have an opinion if the district's rule is being manipulated? And I believe your answer was no. Do you recall that testimony?
Yes, I do, and I believe it is no.
And so here's my question. Are you saying by no, did you mean you have no opinion as to whether the rule is being manipulated, or you do have an opinion and you don't think it is?
Well, I don't think it's being manipulated. I don't have an opinion on it whatsoever.
What's your basis for saying you don't think it's being manipulated?
Well, it doesn't mean anything to me. It doesn't mean anything. People are aware that they need, at least up until that recently, they needed 3 calls in an hour for us to respond. That's it. I don't get into any of the details of that. If people are communicating with others, we need to call in order to get an inspector out there. You know, if that's being done, well, obviously it is being done to an extent that we're responding and we're getting the complaints after hours. But I don't have an opinion that people are specifically manipulating. I think people are complaining because they're smelling an odor and they want it to stop. I think that's the bottom line.
All right. So are you saying basically that it's not relevant to your job whether people are calling each other and advising them to go outside and see if they smell anything, and if they do, to call the air district? That's not relevant whether that's happening or not?
Well, the only relevancy is if we get the calls. It's not like I go to somebody's house and they say, hey, the person down the street didn't call, but they want to complain. That doesn't happen. Each of the individuals make their own complaints through our complaint hotline. And I don't have any opinion whatsoever as far as how often they're calling or when they're calling, or they're all calling within the hour. It just doesn't, it's not part of my investigation or my focus.
All right. So what prompted them to smell the odor is not relevant to you?
Well,
Objection misstates the witness's statement.
I'll rephrase. Is it typically true that on a given night when we're talking about landfill gas odors that you'll receive a call from either Plaintiff 1 or Plaintiff 2, Ellie Katoyan and Roxy Duke-Machen, oftentimes within 3 or 4 minutes of each other?
well, without looking at the actual complaint logs, that I can't really say yes or no.
All right. You don't know whether that was a frequent occurrence?
Well, my reports include all the complaints and the times. So one could just go look at the report and see when did Ms. Duke-Machen contact us, when Ms. Katoyan, or plaintiffs 1 and 2, or witnesses 1 and 2.
Will those 3 households oftentimes complain together on a given evening?
Well, it's typical that they would. They live next to each other or across the street from one another. They're not blocks apart or anything like that.
Well, if you're coming out in a given evening and you're investigating odor complaints within an hour, is it your recollection that generally the pattern is that these complaints tend to come in within a fairly short time period?
You know, I don't want to say in general on that, because sometimes Ms. Katoyan might be not getting home for an hour or 2 after I'm already in the area, or Ms. Duke-Machen, or the other individuals. I mean, there's times, sure, where they're fairly close, and then there's times where they're not. So I don't want to say in a general sense to the board that this is the typical pattern every day, because it's not.
All right. Now, I believe in your NOV summaries, you indicate that sometimes you get calls, say, at 10 o'clock at night, even 11 o'clock.
Yes.
And people say that they've smelled an odor outside of their homes.
Yes.
Do you ever wonder how it is that a number of different people, oftentimes the same people, happen to be outside of their homes at 10 or 11 o'clock at night?
Well, I think you have to look at, people like to keep their windows open, or they maybe walk the dog, whatever reason. I don't ask those questions of complainants. Why were you outside at 10 o'clock at night so that you were able to smell the odor and call the air district? People go about their daily lives, and I think that they're reporting when they're impacted, and maybe, and I might be just surmising this, going outside is saying, okay, I'm getting something inside, I'm smelling an odor, but is this really something that's coming from outside? And go outside and verify. So I really can't explain it any more than that.
Well, you don't know whether people got an odor inside their house or outside their house, do you?
Well, certainly when they report to me that, when I interview a complainant, sometimes they will tell me, I was sitting watching television with my windows open, and all of a sudden this horrible air wafted through my living room. And I went outside, and it was the worst odor. I called SCAQMD. That's how it is.
All right, and then sometimes they say they were outside and they smelled an odor?
Sometimes they say, we just arrived home from out on the evening, got out of the car and noticed the odor, or noticed it 4 blocks away on Balboa, and we drove right up to the house and we're smelling the odor right here and we're calling.
If someone were to say to you, I received an email from Plaintiff 1 and decided to go out and see if I could smell anything, and I smelled something and I called in the air district, would that matter as to whether you would consider that a complaint for a public nuisance?
It would not matter because they called in a complaint and it was verified.
Now, you're aware that a class action lawsuit was filed by Plaintiff 1, Plaintiff 2, and other folks in the neighborhood against the Sunshine Canyon landfill, right?
I was aware, yes.
And are you aware that Plaintiff 1 would oftentimes send an email to the Granada Hills Community website or email server, which I'm calling the Google group, saying, go outside and if you smell something, call the air district?
Well, I'm not aware of what emails that individual or individuals were sending out. They may have said, we put out an email to notify people, but that's not my job out there. My job is to verify an odor and follow up with each complainant. How other complainants are receiving information, or that's something I really don't focus on.
All right. Now, you were asked yesterday by Mr. Sanchez if you felt you were biased against the landfill, and I believe you said no.
That's correct, I am not.
But do you have an opinion as to whether the odors coming from the Sunshine Canyon landfill were avoidable?
Avoidable?
Yes.
Well, obviously there's a problem, and the problem is emissions coming off the landfill. So the reason they're getting a nuisance odor is they're not controlling the emissions. So it has to be avoidable.
Do you have an opinion as to what's causing that phenomenon, whether it's due to the county requirements of 9 inches of cover soil or anything else?
Well, I don't think I can give you an opinion on any specific reason, whether that was a factor or the factor of the inadequacies of the gas collection system or the inadequacies of the cover that they're using or work practices. The fact of the matter is there's issues with surface emissions at the landfill. Otherwise, we wouldn't be having landfill gas odors and trash odors affecting so many people in the community.
Did you ever tell anyone who was complaining about odors at the landfill that the reason for the landfill odors was that Republic was cutting costs?
Well, I don't recall having conversations where I talk about Republic's cost-cutting measures or anything like that. I'm asked generally, what are they doing about it? And I explain to them one of the best ways they can find out is to attend the community, the Sunshine Canyon Landfill CAC meetings to learn what's going on and what's being done, or contact any of the management personnel at the landfill to maybe even have a tour. But I don't get into too much detail on what sort of efforts are not being done or cost cutting or anything like that.
Do you know Mr. Stephen Beck, who lives in the Legends, who, by the way, testified at the first day of public hearings in this matter?
Yes, I know Stephen.
Did you tell Mr. Beck in January of 2013 that the problem with privately owned landfills in the Southern California area is that they cut costs?
Well, I don't recall the specific conversation. You'd have to ask Mr. Beck that. I don't recall anything like that. I don't know the nature of the conversation. And that probably would have been one of the first times that I would have met him as well.
So you're not saying...
I don't have any independent recollection.
So you're not denying you may have said that to him?
I'm not denying what I would have said to Mr. Beck related to private landfills, but I don't know what the details. I don't recall.
When you fill out an NOV form, do you have to check boxes as to what the cause of the public nuisance is?
Boxes? I'm not sure which document you're referring to.
There's a form which indicates whether the emission was due to a lack of maintenance. Does that ring a bell?
Oh, yeah. Okay. So that's in general. Maintenance can be looked upon as maintaining the landfill. We have to check one of those boxes. And that's the box that I've typically checked for that, or usually always check for that. And it's gone through review by management, and I haven't received anything different as far as that being incorrect. So that's why that's done.
Why do you check that box?
Because it's a maintenance issue. If the landfill is emitting odors, it has to do with maintaining the operation or the collection of gases or the management of the waste stream at the landfill. So I'm looking at that as maintenance.
Okay. In January 2013, did Plaintiff 1 send you a YouTube video of an Israeli-Turkish singer?
I did receive an email or a YouTube video back. I don't remember the exact dates or anything, but I did receive I recall.
And he sent it to you because he wanted to know if your wife, who is Turkish, might know the singer?
That seems correct.
So in your conversations with Plaintiff 1, you shared details such as your wife's background?
Yes.
Would it be fair to say that you became pretty friendly with those people who complained fairly frequently about the landfill?
I'm friendly to everybody. That's part of my job.
Right.
As investigating odor complaints. So if we ask them questions about them, and especially if you see them a lot, that's not unusual.
It's human nature.
Yes.
So did you feel that as a result of responding to complaints in the Granada Hills neighborhood going back to 2009 and talking to a lot of the same people year after year, that you formed a bond or friendship with them?
Well, I don't know if I can say bond, friendship. We're friendly. They know me. I know them. That's correct.
Do you feel they look up to you and respect you?
Well, I think they look up to me because I'm professional. I try to be professional. We strive. All inspectors strive to be professional. I don't want to say. I guess I can't really say, because I don't want to diminish that capacity. Looking up, I think they respect us. I think, for me, I listen, and we're responsive, meaning that they complain and we respond to their complaints.
After getting to know these people over many years, don't you feel you want to help them?
Well, I think any inspector is bound by the duty of doing their job objectively and completely. And I'm very conscientious, and I try to be proactive. And we don't want to be going up there every day. We don't want to be responding after hours, disrupting our lives, just as the public is, and complaining. So,
I guess my question is, you form a friendship with these people, you talk to them. Do you feel that you want to help them out? You want to do something to solve their problem for them?
well, we want to be able to tell them we verified the odor and this is what's being done, so that we don't have to come back tomorrow for the same thing.
And so you would verify an odor that ordinarily would not be noticed by the average person, but could be detected by the experienced inspector or a very sensitive individual as a nuisance, even though the odor classification chart doesn't describe it as a potential nuisance.
Could you repeat that? I'm not following you
Right.
on that question.
I'll withdraw the question. You indicated yesterday you were admonished by management not to talk about the class action lawsuit.
That's correct.
Was there something that occasioned this?
I'm sorry?
Well, first of all, who admonished you?
Well, I was admonished by the Assistant Deputy Executive Officer and management.
And who was the Assistant Deputy Executive Officer at the time?
At the time, it was Jill Wynot,
Okay. And-
WHYNOT.
And did she explain why you shouldn't talk about the lawsuit?
Well, it's a civil matter. We don't discuss lawsuits that we're not party to. We don't discuss lawsuits with complainants, period. That's our practice.
All right. May I take just 1 minute?
We're off the record. Mr. Beck, Bruin, how many more questions do you have? How much more time do you need?
Yeah, I have, I'm not going to be able to finish all my questions before lunch. There's one topic I can go into that's probably 5 minutes.
Let's do that and then take lunch.
All right. On March 30th, 2013, did you receive an email from the Granada Hills Community email website containing a link to a class action lawsuit against Republic Services regarding the Bridgeton, Missouri landfill?
I don't recall that.
Do you recall receiving this from Plaintiff 1?
I don't recall.
Let me show you an email to see if this will refresh your recollection.
Well, all I see is a document that says something was sent to me regarding some lawsuit. I get a lot of emails, and I don't necessarily read them if they're not from something specifically related to our inspections or whatever. I get a lot of emails. This may have gone to me, it may have gone into my junk email.
Okay. Just for the record then, the link is entitled Homeowners Tenants Sue Republic Services for Putrid Smells Released from Bridgeton Landfill the Edwardsville Intelligencer, right?
That's what it says.
Okay. On April 2nd, 2013, did you tell one of the individuals complaining about odors from the Sunshine Canyon landfill that you were going to email her information about another class action lawsuit against Republic in another state?
No, I don't recall that.
Let me show you an email to see if that refreshes your recollection. So the question is, with respect to this email, I won't name the individual who sent it to the Google Group email server. But it says, Larry Israel just left. It took him a while to get up to my place last night, and he didn't smell it on my street by then, but smelled it coming up Balboa. He received 6 calls. He is going to email me some info about another class action suit against Republic in another state, and I'll send that to you when I get it, assuming he sends it. Does that refresh your recollection that you had that conversation with the individual who was complaining about odors from the landfill?
Well, I don't remember the exact conversation, but I don't recall ever sending any email out with respect to a class action lawsuit.
Now, the email I just showed you was dated April 2nd, 2013 at 11:05 a.m. I'd like to show you another email. This one from Stephen Beck, and there's an email below it from an individual I will not name, dated the same day, but the time is 11:49 p.m. And my question to you, after you've had a chance to review it, is, didn't you send a link to the class action lawsuit that we just identified to an individual who's complaining about landfill odors on April 2nd at approximately 8 p.m.? So for the record, I won't name the name of this individual, but the email reads at the bottom, Larry sent me this link. Looks like he got it from Stephen, who may have already posted it here. By the way, love that you said that to those men. And the link is entitled, Homeowners, Tenants Sue Republic Services for Putrid Smells Released from Bridgeton Landfill the Edwardsville Intelligencer. Is that right?
Well, I've never seen this before, and I don't recall sending any type of email or link or anything like that.
Do you recall that we discussed this email during your deposition
Chairman.
in the class action lawsuit?
Just a second. Senator?
Mr. Bruin, Mr. Sanchez, what does this email stuff have to do with this particular case?
Well, I can let respondent indicate the point of his examination, but none of this stuff is being admitted in evidence. It's, you know,
Then what is
I understand why he's introducing this,
I
but
don't-
that's for him to argue, but I will just clarify for this document, there's a representation that an email was sent by Mr. Israel. There is nowhere in the chain an email from Mr. Israel to any of the recipients in that document.
in the chain? What do you mean by in the chain?
So there's just a person representing that I received something from Mr. Israel. There's no email from Mr. Israel to that individual.
Were those emails sent to the district and he obtained them here?
No, these are from, I believe, the Google group that Mr. Bruin is describing that communicates about odors in the community. So there are, in these emails, none of which are between Mr. Israel or this group. They're indicating conversations that they've had with Mr. Israel, but nowhere in these emails is Mr. Israel or anyone from the group directly communicating with
If
each
they
other.
have no relevance, how are these emails obtained?
I'm assuming probably from the class action litigation.
So they're kind of mixing in with this case again.
Well, I'll let respondent indicate why he's bringing these in, but essentially they're challenging Mr. Israel's credibility. He's responding to that.
But let him say that.
The board can make a determination on how they want to weigh that evidence, but I will let respondent speak for himself on why he's presenting these documents.
Mr. Chairman, this would probably be a good
Mr.
time.
Brown?
This would probably be a good time for a break,
Would be.
and we can return to this topic after lunch.
Very good. We'll take recess, lunch recess, and reconvene at 12:35. We are back on the record. Mr. Bruin?
Thank you, Mr. Chairman. Mr. Israel, I'd like to help you with your recollection regarding last question about whether you sent a person an email regarding a link to the Bridgeton
Mr. Chairman?
landfill.
Mr. Senator?
Yeah, well, that's the same issue I raised before. We started out examining Mr. Israel on Exhibit 29. Then he went to Section H, but the email is hearsay stuff, not even entering in evidence. So therefore, there's no foundation for discussing it. When he puts on his case, when he puts on his case, then it seemed to me that he can talk about emails as exhibits. It's still hearsay.
Ms. Broussard?
I can allow Mr. Bruin to speak for himself, but at this point, they're merely being used to refresh the recollection of the witness, and they are not being introduced as evidence. Am I correct, Mr. Bruin?
That's correct.
Let's go on.
So, Mr. Israel, in the class action lawsuit, your deposition was taken in that case?
Yes,
And at the time your deposition was taken, you were sworn as a witness, just as you were in this proceeding?
yes,
And there was a court reporter present that took down the questions that were asked by the attorneys in that case and your answers?
yes,
And Mr. Sanchez was present during your deposition in that case?
yes.
I'd like to show you a portion of the transcript, the typewritten transcript of your deposition on this topic. I'll hand it to you and direct you, if I may, to page 165, line 23. And I'm doing this because we're now 2.5 years later, and I believe your recollection at the time is probably the better recollection than what it might be today. And I'm not going to name names when I read this. I'm going to not include the names, and this is a fairly short section. And starting at 165, excuse me, page line 23, this is a question to you. I would like to read you from another email produced by Plaintiff 1 in response to discovery, and it is from blank. That's the name of a person. It is dated April 2nd, 2013, and it reads, quote, "Larry sent me this link. Looks like he got it from Stephen, who may have already posted it here. By the way, love that you said that to those men," end quote. And the link is to homeowners, tenants sue Republic Services for putrid smells released from, it says Richmond here, but it's Bridgeton landfill, the Edwardsville Intelligencer. So my question is, does this refresh your recollection that you received this link regarding another class action concerning Republic Services from Mr. Beck, Stephen Beck, in April of 2013, and in turn sent it on to blank? Answer, well, I'm not going to deny that I received an email from Mr. Beck. If I forwarded it to blank, if it shows that I did, I may have done that. Question, can you explain why you did that? Answer, no. It wasn't. She may have asked either, if I recall, if I haven't had any conversations with her, if I was aware of any other lawsuits. And I may have gotten this and decided to forward it to her just to satisfy her curiosity, nothing more than that. Question, going on to page 167. Do you consider a part of your job function with the AQMD to inform neighbors around the Sunshine Canyon landfill of other litigation regarding Republic Services? There's an objection by Mr. Sanchez, argumentative. Then the answer, not as a matter of course, no, end quote. Does that refresh your recollection?
Well, it reflects my recollection on what I said during the deposition, but I don't recall independently receiving or forwarding anything regarding this link, and I'm not even sure if this is an email I would have received, but, I mean, this is what I said during the deposition.
All right, thank you. Oh, thank you. I'd like to turn to Respondent's Exhibit I, which I believe is also an exhibit of the AQMD, and it is in the Respondent's black binder. It's I as in Indiana. And Mr. Israel, can you tell us what this is?
This is Enforcement Division Policies and Procedures for Public Nuisance Investigation dated May 1st, 1989.
And is this an official policy of the South Coast Air Quality Management District?
It is a policy, yes.
Dr. Lerner has a question.
Yeah, before you continue with this, I just want to be sure, this is dated May 1st, 1989, and now we're going up to about 3 years ago for this discussion. Has this policies and procedures been modified, changed, so that it would have been operative at the time? Can you tell me that?
I'll ask that question. It's a good question. Mr. Israel, this policy that's dated 1989, is this policy still in effect?
I'm not aware of any other policies. This is the one that I was trained on.
And you follow it even today?
Yes.
All right.
I just want to be sure there's been no modification. I mean, it's so to speak, old.
It is.
Okay, thank you.
If you could look at page 4 of this document, it's at the top of the page, it says it's paragraph small c. And I'll just read you the first 2 sentences, which is one I want to ask about. It says, and I quote, "A multiple complaint condition must be documented, period. As a rule, District Legal Counsel prefers that it be based on a minimum of 6 to 10 complainants from separate households," end quote. So this was the district's official policy in 1989, and to your knowledge, it has been the district's policy continuously to this date.
Correct.
So my question is, when do you need 6 verified odor complaints to issue an NOV, and when do you need 10?
Well, policy is always a minimum of 6. The 10 complainants, I can't recall any investigation that I've done where there was a minimum of 10. It's always been at least 6 or more. So I can't speak to why they're putting or why it has that particular range, but we are always following the 6 rule minimum.
Well, you refer to this as being a range, but doesn't the wording say a minimum of 6 to 10?
It does say that?
So 10 is also a minimum?
It's not our direction as compliance inspectors, the number 10. It's a minimum of 6, so we need to get 6 in order to issue the violation notice.
Well,
and
just to
establish a nuisance.
Just to be clear, you don't read this policy as saying that if you get 11 complaints, you can't issue an NOV. It's not a top end, right? It's still a minimum of 10.
Correct.
Mr. Chairman,
Senator?
Mr. Bruin, will you continue to read however in that same paragraph?
If you want me to read the next sentence, I'd be happy to.
Tells you that it can be less than 6 or less than 10.
Yes, it does.
Well, then I think that point should be made.
Okay, I'll read it. However, Special circumstances may dictate that a notice of violation be issued if supported by fewer complainants. For example, if property damage or a potential health hazard exists, a husband and wife living at the same residence may be considered as separate complainants. A notice should not be issued only on the basis of complaints from members of a single family living at one location. So the special circumstances referenced in this rule, Mr. Israel, talk about an example being property damage, right?
Correct.
So for odors, your understanding is the policy would be 6 to 10?
The policy that's in place right now is a minimum of 6.
Is there something else in writing that's been approved by the Air District that says, even though this policy talks about a minimum of 6 to 10, it's really just a minimum of 6?
Well, there's no official policy that I can recall where it differentiates anything more than a minimum of 6 to 10 as listed here. But we've always followed, or I've always followed the 6 minimum rule, and that's been the way that I've always applied the rule.
All right. This is how you read the rule and how you've been applying it at Sunshine Canyon.
Not just Sunshine Canyon.
Other locations as well.
Yes.
Have you ever required more than 6 complaints to issue an NOV?
For public nuisance?
Yes.
No.
Okay. Now, if the rule required were that you needed a minimum of 10 verified complaints as opposed to 6, would it be true that instead of 63 NOVs for evening odors, you would only have been able to issue 12?
Well, if the requirement is that a minimum of 10, then one would eliminate all those where there are less than 10. So whatever that number is.
All right, thank you. I'd like you to turn to Exhibit E in Respondent's Binder. And once you get there, I'm going to ask you a question about Section D, page 9, and the way, Mr. Chairman, for the board members to find that is there's a box in the upper right-hand corner of these pages that has the section and page number. So the sections are alphabetical, and of course, each section is numeric. So first of all, Mr. Israel, can you tell me what Exhibit E is?
This is the facility permit to operate. I believe this is the Title V permit issued to Sunshine Canyon Landfill, dated November 25th, 2014. It's revision number 8.
And this is the permit to operate the landfill issued by the South Coast Air Quality Management District. That's,
Excuse me one second. The senator's having a hard time. It's D9, page D9, up on the top upper right-hand corner in the box. So section D, no. It's Exhibit E, but it's section D of the permit, page 9.
Okay.
I think I was asking, I apologize, I don't know if I got an answer, but I just wanted to ask. This is the current permit to operate issued to the landfill by the South Coast Air District?
I believe it is, yes.
And as the inspector primarily assigned to the Air District, it's your job to inspect the facility for compliance with this permit?
That is correct.
And this is sometimes called the Title V permit,
That's correct.
and that's because it's issued pursuant, in part, to the authority of Title V of the U.S. Clean Air Act.
That's correct.
Right. If you would look to Section D, page 9, and this is under, if you go back a couple of pages. No, don't do that. Just stay on page 9. If you look at page 9, it talks about construction at the landfill.
Correct.
And one of your jobs as the inspector for the air district at Sunshine Canyon is from time to time to observe that if construction is taking place on the landfill, it is being done in accordance with this permit.
Correct.
And there's a provision at the top of page 9, paragraph 15, which reads, if a distinct odor level, paren, level Roman numeral 3 or greater, end paren, resulting from the construction is detected at or beyond the property line, all work shall cease until the odor sources are determined and eliminated, period. Odor levels shall be determined by SCAQMD personnel or on-site safety coordinator in the absence of SCAQMD personnel. And then there's a reference to Rule 402 and Rule 1150. Did I read that accurately?
Correct.
Now, the reference to the need to stop construction if a distinct odor level, level 3 or greater, is found during construction, that's a reference to the odor classification chart we were looking at earlier, which is Exhibit H. Is that right?
You know, I don't know the answer to that. I don't know what level 3 is.
Well, if you count from the bottom, distinct is the third level. And it does use the word distinct, and so does the Title V permit use the word distinct. But being in charge of enforcing this permit, do you have an understanding of what paragraph 15 means when it talks about distinct odor level, level 3 or greater?
Well, I don't know, and my experience, level 3 or greater, I mean, it's reasonable that's what they're referring to, this odor classification. I don't know independently. This particular issue I have not had a problem with, so I can't really speak. You know, this condition may be a boilerplate condition, a general condition, but I can't really comment what level 3 or greater is, other than it says distinct odor when comparing it to the odor classification.
Do you have any reason to believe that the reference to distinct odor level in this Title V permit does not refer to distinct odors as described in the Air District's odor classification chart?
Well, again, I'm not sure where that condition came from, if they're taking that information based upon that exhibit for odor classification. I just don't know.
Well, if you're inspecting the facility for compliance with this provision, do you read it to indicate that if a odor level less than distinct is found at the property line during construction, it's okay for construction to continue?
Well, this is specifically, I think this condition is specifically related to trenching activities or installation of gas wells. But again, if we're responding to a public nuisance, that's referenced here, but it's not what drives a public nuisance. So for me to say, yeah, they should cease all construction work, I think is a very, very general term as applied. That's all I can say on that.
Well, let me try to rephrase my question so it's clear. What I'm trying to get at is I'm asking you whether you read this condition as suggesting that there can be odor from construction at the landfill, but construction can continue so long as the odor level does not rise to distinct odor level 3.
Well, I mean, that's how you would read this. That's how we would interpret it.
So doesn't that mean that if you smell an odor at the property line during construction that's faint or very faint, you would not stop construction?
No, I don't think we have the authority to stop any construction activities. And if it's part of a public nuisance, that's separate.
Understood. But this condition says if a distinct odor level, level 3 or greater, resulting from the construction is detected at or beyond the property line, all work shall cease. So you don't read this permit as allowing you to stop work if there's a violation of this condition?
Well, I can't say that I've actually verified this particular condition as a violation.
I understand that. I'm just asking you how you interpret this permit, which is your job to enforce.
Yeah. Well, it says that all levels or all work shall cease until the odor sources are determined and eliminated. Even if we detected odors resulting from a specific trenching activity, you know, we're on site and observing the activity as it's occurring, and this is suggesting if we go off-site and we make a determination that the odor levels are at a level 3, and therefore we can go back and tell that work to cease and eliminate the odor source. In practice, I've not done that.
Understood.
It's not been an issue.
I understand it hasn't been an issue, but my point being, you said you didn't have authority to stop construction, and I'm respectfully suggesting that you do. Do you agree with me?
Well, that's not a policy that we have in place. Even with this specific condition right here, I don't think that that's the actual intention of it, that we go out there and stop the work. We could look at it from the standpoint that they're violating a permit condition by not ceasing, but I don't think we have the authority in place to say that that particular activity needs to cease. And it's actually something that's above my background and authority.
So, okay, so then if I ask you whether it's okay for construction to continue so long as the odors do not reach a distinct odor level, level 3, would your best answer be you're not sure what that means?
No, I'm just saying that I don't think I have the authority to have a particular activity cease. In this particular case, or looking at this condition, I think our policy would be that the work, if it continues because it's been confirmed to be generating an odor at level 3 or greater, or distinct odor at the property line, would be in violation of the Title V permit condition.
But don't you read this to say if the odors are less than level 3, construction doesn't have to stop?
Well, yeah, if it's less than 3, it's only talking about distinct or greater.
Thank you. I'd like to talk about the subject of any scientific or objective odor testing that has been done in connection with the landfill. So the first topic is air samples. You testified yesterday that you had taken several air samples, and you described a scenario where you would take a Suma canister sample in the neighborhood when you smelled a particularly strong odor. Then you would go to the landfill, if it was at night, for example, and take an air sample near the entrance of the landfill. Did I get that right?
Well, it would actually be on the landfill's site itself, yes.
Right, so you'd go through the entrance gate?
Yes.
Okay, and when you were on the landfill itself, where would you take this sample?
Well, usually, always on the main haul road. So I don't deviate from traveling on the landfill property after hours for safety reasons. But the samples were always collected on the haul road.
Okay, and the haul road in the landfill is surrounded by, once you get through the gate, it's surrounded by the old city landfill on the left and newer landfill operations on the right?
As you're going north, the city, yes, that's correct.
So basically, the air samples on the landfill property were taken at a location where you were surrounded by either new or old waste disposal areas.
That's correct.
Okay. And then when you would take a air sample in the neighborhood, you would take an air sample at a location when you were issuing a notice of violation typically?
No, not typically.
Would you take the air sample when you felt the odors were particularly strong?
The directive I received was to collect an ambient air sample when I detect an odor.
All right.
I chose to take an ambient air sample when the odors were distinct, something very noticeable to me.
All right. So you wouldn't take an air sample when the odors were faint or very faint, but rather when they were distinct?
Correct.
All right. Now, there are a number of, and I think you described the chain of custody. You would bring the SUMA canisters to the Air District lab, which would then test them for air contaminants that were in the samples?
Correct.
And the district has on its exhibit list a reference to a number of the air samples that you took. And my understanding, thus far, we've received 5 laboratory reports from the Air District lab who is running the reports on those samples. Are you aware of that process?
I'm not aware of that process.
All right, okay. To your knowledge, were any of, and these were samples that have been taken since or during the last part of the last part of 2013 through 2016. Did you ever see any reports on those air samples?
I was forwarded at least 1 or 2 that I can recall in the last 4 or 5 years, but I did not, and I don't have any background in analysis where I can talk about the results or anything like that.
All right, so you can't really opine as to whether they showed anything or not.
No, sir.
Now, when you take a SUMA canister sample, could you briefly describe how you take the sample? In other words, do you hold the canister a certain length from your body? Is there some protocol you have to follow?
Well, the training that I've received on it, and it's the training involves being shown by a lab tech on how to collect the samples, usually at the breathing zone. So you would hold the canister with the opening facing out towards the direction of where you believe the odor is coming from, and just open the valve up. It draws in an air sample, takes about 20 seconds, and you close it up and put the cap back on, and that's all there is to it. Just document the time and the location.
And is it your understanding that the purpose of these SUMA canister samples is to capture those things called non-methane organic compounds that might be in the air?
The objective was to collect a sample of the ambient air. That might be what they're looking for in the analysis. I really can't say. My direction was to collect a sample of the ambient air.
All right, and when you use the phrase ambient air, what does that mean?
The outside air, the air that we're breathing.
Okay, thank you. So other than the air samples that you have taken and are currently being analyzed by the Air District Laboratory, and again, we've received 5 of those reports to date, and I understand more are coming. I want to ask about some other testing. We've heard some testimony that people in the neighborhood have complained about a rotten egg odor or a sulfur odor. Are you familiar with what chemical compound that odor is associated with?
Well, when I think of that, I think of hydrogen sulfide, H2S.
Right, and is H2S oftentimes called sewer gas?
It is a byproduct, yes.
So that's oftentimes found in sewers?
Yes.
Does the Air District have equipment that can measure the concentration of hydrogen sulfide gas in the air?
I believe, and I can't say, I don't want to speak for another section, but our special monitoring or air monitoring people do those sort of tests. They would be the best people to ask. We in Toxics, we don't.
Okay, so
We don't collect those samples.
So sitting here today, you don't know if the air district can take air samples or use a probe of any kind to test for hydrogen sulfide gas in the air?
No, I wouldn't say that. I don't do it, and the unit that does do it, special monitoring, they do our air monitoring throughout the basin. They would be the ones that could answer that question.
Okay, I'm sorry, I'm getting a little confused about your answer, and I'm sure it's my fault, but are you saying the district does have the equipment to monitor H2S? You're just not familiar with the details?
Yes.
Okay. So my next question is, has the district taken any air samples or done any monitoring for hydrogen sulfide gas at the surface of the landfill versus areas in the neighborhood?
I don't know.
Who would know?
Well, I gather you'd have to ask, since it's not done by inspectors, you'd probably have to ask the district's laboratory or special monitoring.
Okay. Now, in 2011, there were hearings before this hearing board in November and December. And as a result of those hearings, there was an amended abatement order, stipulated abatement order approved by this hearing board, which called for 1 year's worth of odor monitoring at the landfill and at the Van Gogh School. You aware of that?
Yes.
And are you aware that this odor monitoring was done pursuant to protocols or procedures that were dictated by the South Coast Air Quality Management District?
Well, I don't remember the